Hello friends, welcome to the Now Affair. Today in this video I will give in-depth analysis on triple talaq and its implications. Let's start with it. As per news, a 5-judge constitution bench termed the triple talaq practice as unconstitutional with a 3-2 majority. Talaq-e-bid'at or instant and irrevocable talaq was called manifestly arbitrary practice and is not protected by Article 25, Freedom of Religion, of the Constitution. Now, let's talk about the background of triple talaq. Triple talaq in all its 3 forms, talaq-e-bid'at, talaq-ahsan and talaq-ahsan, was recognized and enforced under Section 2 of the Sharia Act of 1937. Ahsan and ahsan are revocable. Bid'at, pronouncing divorce in one go by the husband, is irrevocable. Bid'at is considered sinful but permissible in Islamic law. Thus, since Sharia Act had recognized triple talaq, it was no longer a personal law to remain free of the fetters of the fundamental rights rigor but a statutory law which comes under the ambit of Article 13(1) of the Constitution. Article 13 defines law and says that all laws, framed before or after the Constitution, shall not be violative of the fundamental rights. There were 3 sets of judgments given in this matter. According to the first judgment, minority judgment of CJI and other justice which said believed that court had no right to tinker with religious personal laws, which enjoy special protection in the Constitution. As per the second judgment, the majority judgment said that the practice was against the teachings of the Quran and, therefore, violated Muslim personal law. And, the third and the final judgment talks about the state of abandoning the triple talaq pronounced in one go. The Muslim Personal Law Board has welcomed the decision and said that it was not supportive of the instant triple divorce. It had inserted a clause to curtail this right of men long back while providing a model nikah. There was also an advisory that all the people doing the triple divorce in one go will be boycotted socially. The Maulvis and Qazis were advised that they must tell this at time of nikah. However, the enforcement have been not strong enough. It is true that there is lower incidence among the Muslims. But the fact remains that a Muslim girl grows with the consciousness that the unrestrained right is available to the men and after her marriage, the husband can turn her out of the marital home for any reason. This feeling still persists among Muslim women that they don't have equal rights of divorce and thus gender equality is still a long battle to be won. Let's look at some of the implications of this verdict. It is a progressive judgment. This judgment should not be politicized for regressive agendas on either sides of political debate. All that the Constitution says is that one form of divorce available to Muslim men is not permitted henceforth. So it is not that other forms of divorce are not available. The repetition of talaq over 3-month period is valid and law will accept it. Rights under Art. 25, 1, as far as religious freedom is concerned are not available only to minorities but all. The state's right to intervene in anybody's rights or at least religious rights is equal across the board when it comes to legislative mechanisms being used to user and social welfare. The reason why triple talaq has been rendered unconstitutional at least by majority judgments say that triple talaq is not seen as an essential part of practice of Islam and therefore it is not an essential part of the faith. Thus it cannot seek the benediction of Article 25, 1, so far as religious freedoms are concerned. Therefore there is no need for a separate law for it to be banned or forbidden. The 6 months injunction is part of minority judgment. The majority judgment essentially holds the practice of triple talaq to be unconstitutional. Impact on Indian society. It will have a positive effect on Indian national life. The courts have intervened that this particular practice and form of divorce which was otherwise protected under the Sharia Act of 1937, to that extent and provision, the Sharia Act is unconstitutional and thus there will be no more triple talaq. There is a balance between being progressive and abiding by constitutionalism because the biggest fear in these kind of judgments are severe complexities that creep in where injustice is tried to be done at expense of Constitution and its interpretation. But it hasn't happened in this case. The court has abided by the Constitution and come out with a categorical finding. To conclude this analysis, This judgment is important also for a general right of a citizen to approach the court and strike down irrational law related to religious belief. However, it should be present as some part of the religious act or a law. This would be useful in a second challenge to Section 377 of IPC because every law which is arbitrary is liable to be struck down. This is true importance of the judgment. Thank you for watching this video. Please like, share and subscribe the Now Affair channel for more analysis and news updates. Stay tuned. Till then, goodbye and take care.